by the current DBM Secretary, Kim Robert C. De Leon, entitled Programming for Unprogrammed, Unbundling the Unprogrammed Appropriations, which was published in 2025 as part of the UP-NC PAG Working Paper series. It was written and published when Secretary De Leon was still assistant professor in UP. You know, I got hold of this paper during the oral argument on PhilHealth. But I just checked it last time. It was not available anymore online. At any rate, it was written and published when Secretary De Leon was still assistant professor in UP. In his paper, he observed that, and I quote, the use of UAs to serve as appropriation cover for ongoing foreign-assisted projects poses a possible breach of contractual obligations with foreign lenders, as well as widening of the government's fiscal deficit. He noted, and I quote, when Congress transfers the loan proceeds component of foreign-assisted projects from program to the UA and proposes a new set of local projects in lieu of such loan proceeds, Congress is actually putting pressure on the executive to borrow more for those local projects that took the place of loan proceeds, since such loan proceeds can only be disbursed for their designated purposes. Meanwhile, the executive is duty-bound to release allotments for the loan proceeds component of the foreign-assisted projects, even when lodged under the UA, because of contractual obligations with the foreign development partners and multi-year contracts entered into with the respective contractors. I would like to restate this using my own words. In other words, when a foreign-assisted project with existing funding is moved from programmed to unprogrammed appropriations, in reality, the transfer covers not only the project, but also the transfer of the fund itself, so that whatever space in the programmed appropriation that seems to have been created by the transfer is merely artificial. In truth, there is no more remaining fund to cover the new project, created to fill the so-called fiscal space in the programmed appropriation. This is the reason the new project will compel the executive to secure a new loan, since being now classified under programmed, it becomes a commitment on the part of the executive. So this is one of the triggers for unprogrammed funds, which is not allowed for programmed funds or appropriation. Do you agree with these statements by the present DBM Secretary, Madam Solicitor General?
Your Honor, yet theoretically that could happen, and our discussion then, when we were asking questions about the transfer of FAPs from program to unprogrammed, what should happen really is that the appropriation, the project, the project and the source of funding should both be transferred from the programmed to unprogrammed, such that if there is a space that is freed up in the programmed appropriation, then there should also be a corresponding source of funding for that, because the source of expenditure for the FAP should have also been transferred to the unprogrammed appropriation. So that is our understanding.
So what is the point of creating the space when there is no remaining fund? And what is the point of moving these projects which are funded to the unprogrammed funds when everything follows, not only the project but also the funding? So what's the point of moving it?
Your Honor, our understanding is that then it will not be part of the fiscal space that is occupied by other projects.
You know, the fiscal space that is created is merely artificial. You know, needed for the funding of the foreign assisted project simply because it is already funded. No trigger is needed there. So why move it for the creation of the space, and then the space that has no funding, and the space that the funding of which is actually triggered only by any of the triggers under the unprogrammed fund. So there is confusion.
Your Honor, and that the technical experts can correct me.
Yes.
So, in fact, as you are propounding your questions, I'm thinking that the FAPs should actually be lodged in the unprogrammed appropriation.
Is that correct? Or it defies the very definition of unprogrammed, and you cannot divert the funding for the foreign assisted projects because otherwise it is misappropriation.
If I may, Your Honor, while it's true that once you transferred an ongoing foreign assisted projects to the UA, that goes with it the corresponding funding source, which is the loan. And you're correct, Your Honor, there's already an approved loan, so there's no more technically a need for trigger. However, what I have heard, based on conversations also coming from Congress, that the reason that they would also transfer, for example, a DOTR project in the program transferring to the UA is that the utilization rate of that agency may be slow, and in the spirit of urgency, this
Maybe slow.
Yes.
Maybe slow.
Ma'am, Your Honor, there's
That is speculative. You know, what I remember is this. It only becomes slow because there's no available funds.
that's also
And
correct.
one
Yes,
of
Your
the
Honor.
reasons pointed to is the delay with DBM with respect to the release of funds. This one should not be moved to unprogrammed when, my gosh, it is so programmed. And, you know, moving it to create the space, it is not visible to the naked eye.
Yeah.
You know, did you notice it?
Your Honor,
No ordinary Filipino will see that. You know, you need not only a 20/20 vision, you need microscopic lens to see it. So it's cloaked into secrecy. Until now, until I've read that paper, I was of the impression that when you move the projects, the foreign assisted projects, you leave behind the fund, which I pointed out during the oral argument in PhilHealth, that is anomalous because we are committed for the purpose for which that was that loan was borrowed and lent to us. And then I reread. I can't believe that we're moving everything to the unprogrammed funds and leave an artificial space that doesn't carry any funding at all. And so the government is committed to produce that by all costs because it is a commitment. And that's not easily noticeable. You have to really make extra effort to determine that that is what is being done to the movement, to the program, to unprogrammed funds, from program to unprogrammed, insofar as our foreign assisted projects are concerned. All right. So, in 2024, I hope you have this data. How much did the government borrow to fund the local projects that took the place of the FAPs in the program appropriations? How much did we borrow?
Your Honor, I'm just looking at my...
All right, if you don't have them now, please submit them next time. And may I gently remind the parties, including the good Solicitor General, that of your commitment to produce some documents that the court required last time.
Yes, Your Honor.
Yes.
We already requested the DBM for the data, Your Honor.
Ma'am, I have it here, but if you would want to still ask
Yes,
for that.
please.
For 2024, the financing that the Bureau of Treasury contracted for a loan was 1.3 trillion.
Yes, that's quite a sum. All right. So, how do we now say that the unprogrammed appropriations are neutral deficit?
Your Honor, may we clarify, because I think that the good representative from DBCC mentioned a figure that refers to the total borrowings and not the one that
Yes, please clarify that in your submission to the court. So, I go back to my question. After this has been uncovered, how can we now say that unprogrammed appropriations are deficit neutral insofar as the foreign assisted projects are concerned?
Your Honor, because of the nature of the unprogrammed appropriations, and that's why our position is that they are generally not deficit-inducing. They should be deficit-neutral.
I'd like to zero in on the foreign assisted projects.
And
so
yes.
when that is done by the government, how can it be neutral, deficit neutral, when the government is compelled to produce the amount for that project that filled the so-called fiscal space?
Yes, we appreciate, Your Honor, the point that is being made. So for FAPs, I think that what should have been done was to also give an additional source of funding for the one that was moved to the unprogrammed appropriation. And I think also...
So how can it not be deficit generating, enhancing? When the deficit, say for example, is only 200 billion, but because the Congress created a new pet project, a new project, underprogrammed, which does not have an existing funding, but the government is committed to fund it. So the 200 billion is increased. For example, the deficit is only, say, 50 billion. So with the creation of a new project to be funded by commitment by the government, you add to 50 billion deficit.
Our after me. Our appreciation, Your Honor, is that there should be another source of financing that should be provided in the programmed appropriation and not a borrowing in order to not result in a deficit.
It's still deficit. You still have to find the funding for that project.
Your Honor, because the sources of financing, for example, have to be adjusted as well. So if the executive is committed, for example, for GOCC, if they identify that the target is 20 billion, then the executive has to adjust and increase their target.
That's the problem there. You sacrifice the original items that have been programmed by the government. All right, just to accommodate this item that seemingly filled a fiscal space when in fact there is no fiscal space to speak of because there was no funding and you need a trigger for the funding to be produced. All right. Anyway, it is NEDA's position that budget and funds flow is the most frequently reported issue in the implementation of the ODA projects. Can you follow? Yes?
Yes,
I'm not done yet. All right. In particular, the absence of programmed budget allocations in the GAA and the reclassification of funding to UA, which requires revenue availability and DBM clearance delayed releases, actually, disrupted procurement schedules and pushed back implementation timelines. I would like to read the words. This is the Department of Economy, Planning and Development. That has been published. Okay. It reported that, and I quote, despite the state policy emphasizing the importance of having counterpart funds for implementing ODA-funded projects, among the recurring issues reported is the unavailability, insufficiency, or delayed release of project budget, which causes delay in project implementation. For example, the local governance reform project did not receive any allocation under the fiscal year 2024 GAA and had to rely on a UA request despite having continuing funds. Meanwhile, the capacity building to foster competition project, CB's FCP, received only a minimal GAA allocation, which is insufficient for its planned activities. The PCC requested additional funds under the UA, but was not provided with the required government counterpart funding. Without this, the PCC was unable to utilize loan proceeds as the counterpart is needed to cover taxes and duties. Delays were also linked to late budget requests and local election-related disruptions. Some agencies mitigated the issue by using prior year allotments, requesting special fund releases, coordinating closely with oversight agencies, and adjusting implementation timelines. Notably, DOTR accounted for 55% of all affected projects and is preparing a request for DBM for additional funding under the FY 2025 UAA. So, with this report of our own economic managers, Dev, the former NEDA, what flexibility are we talking about here? You know, the government seems to have equated the presence of unprogrammed appropriations with flexibility, convenience, promptitude, progress, service, and a saving grace against penalties from our foreign creditors. With this report from a government agency itself, the Dev, are we talking here of flexibility in a good way or flexibility in a bad way? Flexibility that triggers increased budget deficit, increased penalties from our foreign creditors, bad credit standing of our country, and more foreign and domestic debts. And where is the progress we are talking about that is triggered by unprogrammed appropriation? Madam Solicitor General, can you respond?
Is being considered now is an interplay of the powers that are exercised by the executive as well as the legislature. Because the executive would have like the technical reports.
Madam Solicitor General, so you're talking of moving forward.
Your Honor, what I'm trying to say is, for example, Dev, they continue to have maybe technical papers. Even our Congress would
So
also...
we are talking of moving forward. But this court is looking at it backward. Yes.
Yes,
you seem to be, you know, looking at the bright things of life.
Your
and
Honor,
that's good. Yes.
Yes.
Moving forward, we shall remedy this, we shall do this, we shall, etc. But the reality is still before us.
Yes, Your Honor. I'm just trying to say that even, for example, the executive would undertake a step, but it continues, its technical experts continue to study and maybe come up with recommendations that are finally, for example, not adopted by the decision makers. So all I'm saying is that the government isn't really, and I think that's a healthy fact that each office, each agency would come up with their own stand, but of course some decisions are left to the decision makers. So even if...
All right, just to focus on the stand of NEDA, this is a report by NEDA. What's wrong with the report of NEDA?
My appreciation, Your Honor, is that the NEDA would recommend its study certain courses of action, and then I think to the DBCC.
So which part of NEDA's report is untrue?
No, I did not mean to say that they are untrue.
Yes. So far, do you agree with the conclusion of NEDA?
Yes, Your Honor.
Yes. So you agree that there is a flaw, a serious flaw, in moving programmed to unprogrammed?
Yes, Your Honor.
Yes.
So the NEDA continues to study and maybe make the recommendations to
Yes.
their principal.
Good luck to NEDA.
Former Senate President Drilon mentioned about this already earlier. And I want to ask the position of the government on this. Is unprogrammed appropriation as a concept, is it a tool inherently designed to facilitate corruption? Or is it a neutral mechanism that may be utilized for corruption depending on its implementation?
Your Honor, the position of the government is that it is not inherently a tool for corruption. Number one, the unprogrammed appropriations has been present in our GAA since 1989. So from the presidency of President Cory Aquino until the current administration, the UAs, and twice in that period, have been considered by the Supreme Court in regard to its constitutionality or unconstitutionality. In Belgica versus Ochoa and in Araulio versus Aquino, the Supreme Court has given as well what are the parameters, when should an item be a valid item. And Congress has in fact followed, the Senate and the House of Representatives have followed religiously in regard to the Araulio versus Aquino. If I may also insert the position of the government, that our reading of the Araulio versus Aquino is that it was not a constitutional provision that the Supreme Court interpreted, but it was a statutory provision. It was a trigger in the GA.
Chill lang magbayad sa G-Bills. Your bills in one app. Choose a biller, pay your bill.
By the DBM to the revision in the articulation of a statutory trigger. Now, we all know as citizens of this country, many have been angered by what has happened in the 2024 budget. And I think that the political branches have also undertaken steps to course correct or to self-correct itself because being political branches, they were also reacting to the emotion, to the public anger, and therefore they were also addressing the issues posed by the unprogrammed appropriation. Another reason, Your Honor, that I say that it is not inherently was designed to be a tool for corruption is that in many instances in the past, the administrations, the executive have actually relied on the unprogrammed appropriation, especially during the time of COVID, that President Duterte really tapped the funds on unprogrammed appropriations. Are they vulnerable to abuse? Our position is that any power, I would say, is vulnerable to abuse. And that's why we also tried to point out in the last oral arguments that the PDAF that was considered by the Supreme Court in Belgica versus Ochoa was in fact under programmed appropriations and not unprogrammed. So if there is really a intent, unsoundness or lack or absence of wisdom to our political branches, I think that any mechanism that is provided them or any power may be vulnerable to abuse, Your Honor.
Now, to the Solgen, reiterating the question previously of Justice Javier, in terms of the budget preparation and the GAA, why not just include unprogrammed appropriations under programmed appropriations? Why is there a need to distinguish between programmed appropriation and unprogrammed appropriations? And what are the real consequences if unprogrammed appropriations are removed or abolished from the GRAA?
Your Honor, the mechanism of the unprogrammed appropriations has been used by the political branches in order to have the flexibility in terms of the fiscal space that the executive has deliberated on and has planned with regard to deficit level. So it works within a fiscal space, Your Honor, meaning if it is able just to commit to an X amount of revenues, then that means that the executive will undertake to earn those revenues in order to fund the programmed appropriations. Other than that, it does not find a power or capability to commit to funding other important programs which we find in the unprogrammed appropriations. So meaning, if all of the unprogrammed appropriations will also be included in the programmed appropriations, then there will be breach, for example, of the deficit level that they think is a sound deficit level. And if I may also mention that even the first world countries have a planned deficit spending. So or adopting a deficit spending framework isn't inherently bad. And what the question should be is how sustainable it is. And maybe our representatives also from DBCC could explain that even in the medium-term fiscal framework, there is a target each year until like 2028 where the ideal level of deficit should be achieved. Deficit spending is not bad because if the executive and the Congress will invest in certain projects that have better multiplier, higher multiplier effect, then the economic impact will be more positive. So, Your Honor, it's actually the fiscal space that forces the executive to put in the unprogrammed appropriations. And again, may I reiterate that in unprogrammed appropriations, if there will be no excess or if the triggers are not attained, then there will be no funding for the unprogrammed appropriations, Your Honor.
Soljan. So, Soljan, the Constitution vests in the Congress the power of the purse. And the court recognized this in Pelconza versus Enriquez as well as in Angnar's party list versus Executive Secretary. But the Constitution requires the President to submit to Congress a BESF, a Budget of Expenditures and Sources of Financing. Does this mean that the Congress is bound by the budget proposal submitted by the President?
Okay. Your Honor, with regard to the BESF, then the Congress is bound to observe the ceiling with regard to the BESF as presented. And it is our position that the unprogrammed appropriations being supported by funds that are not in the BESF, then they are not part of that prohibition.
The power of the purse granted by the Constitution is not unlimited, correct?
Correct, Your Honor.
So, this is not a purely political question.
Then, yes, Your Honor.
To what extent then can this court review the exercise of the power of the purse particularly on the inclusion of the UAs in the GAAs?
Your Honor, it is the position of the respondents that there are constitutional provisions that we have to check vis-a-vis, or we have to use these constitutional provisions and see if there has been a violation, which is the Article 6, Section 25, Paragraph 1, which is addressed to the legislature that they may not increase the appropriations recommended for the operations of government. Article 7, Section 22 is also a limit. It refers to the BESF, and it is addressed to the executive, to the president, to submit that, and that the form, content, and manner of preparation shall be prescribed by law. Also, the provisions in the GAA must be related specifically to a particular appropriation and limited in its operation to the appropriation to which it relates, which is Article 6, Section 25, Paragraph 2. Also,
Happy birthday! Tara! Cake na tayo! Happy birthday to you! Thanks for the cake and party. Rich chocolate, moist and yummy. Can't wait to eat already. We just love the best tasting. Red Ribbon Chocolate Dedication Cake. Simply irresistible.
which has been laid down also in Atitio versus Zamora by the Supreme Court. So, Your Honor, it is our position that all these constitutional provisions, we check on whether there was a violation, and it is our position that there was none.
So in short, you are saying that the power of the purse is limited by the textually demonstrable and judicially discoverable standards laid down in the Constitution. Am I right?
Yes, Your Honor.
So to the OSG, yeah. What standards should this court assess the constitutionality of unprogrammed appropriation in the GAAs? What should be the guide of this court? Any jurisprudence saying what guide should we follow in assessing this?
Your Honor, the number one would be if there has been a constitutional provision that has been violated in recognition of the expanded judicial power of the Supreme Court. The other question is that if there has been grave abuse of discretion. And Your Honor, we found a case, Defensor Santiago versus Gingona, where the court had two issues on whether there was a violation of the Constitution, and number two, whether there has been grave abuse of discretion. Now, in Defensor Santiago versus Gingona, their number one finding is that there was no violation of the Constitution, since the Constitution was silent on the manner of selecting the officers in both chambers. Now, they proceeded to the next question. If there is no constitutional violation, can the court inquire into grave abuse of discretion? And then the court proceeded to define what grave abuse of discretion, and if I may be allowed to read, yes, Your please. Honor, grave abuse of discretion is such capricious or whimsical exercise of judgment as is equivalent to lack of jurisdiction. The abuse of discretion must be patent and gross as to amount to an evasion of positive duty or a virtual refusal to perform a duty enjoined by law, or to act at all in contemplation of law, as where the power is exercised in an arbitrary and despotic manner by reason of passion and hostility. And the Supreme Court proceeded to say also that absent any clear-cut guideline, in no way can it be said that illegality or irregularity tainted Respondent Gingona's assumption and exercise of the power of the office of the Senate Minority Leader. And that where no provision of the Constitution has been clearly shown to have been violated, disregarded, or overlooked, grave abuse of discretion cannot be imputed, Your Honor.
Sergeant, what weight do you think is required to...
Your Honor, it's proof beyond reasonable doubt, which has been cited in the municipality of San Mateo versus Smart Communications, which I understand was penned by your good self.
Thank you.
We also had a survey of several other cases which reiterated the same. So it is proof beyond reasonable doubt. It works on the presumption of constitutionality of the acts or of the laws that have been passed by Congress, and as also revealed in the last oral argument, Your Honor, when the good Justice Amy Javier also asked the petitioners, it is our humble appreciation that the petitioners were unable to give their justification for the allegations that they have included in their petitions, Your Honor.
It seems to me that the guardrail imposed by the Constitution on program appropriation is the ceiling as contained in the BSF, as you stated a while ago. What then are the guardrails for the unprogrammed appropriations?
Your Honor, the same provisions of the Constitution, because